Good morning, everybody. This is Dan Bouchard. Welcome to the required broker update for what are we in March for Virginia. Today's topic is going to be including everyone with legal stakes in the property in the negotiations. And really, this case that is going to be presented is a commercial case, but it applies to residential as well. And it doesn't really matter to the jurisdiction, so this applies to all jurisdictions. So we're going to jump into this. A real estate broker listed a commercial property on behalf of its owner who planned to relocate his manufacturing business across town to accommodate future growth. Several months went by before a buyer emerged and submitted an offer through his own broker. After extensive negotiations, the parties decided to move forward and enter into a contractual agreement. The property owner had a silent partner who was unaware that the property was going to be sold. So, silent partner, this could be in an LLC. This could be, in a residential situation, would be less common to have a silent partner, but it would be possible to have a silent partner like somebody who was added to the deed after the purchase, for example, and may not have shown up already. Or maybe there is a claim to equity ownership in the property from somebody that hasn't been recorded. So it's important to have these conversations with your clients when you're listing to make sure that they understand that if there's anybody that could be used that could make a claim to ownership interests, they could, that they need to disclose that to you as the listing agent right away. All right, so the problem, the owner had a silent partner. The mistake, the broker allowed the owner to sign both the listing agreement and the purchase agreement. And in a sentence like this where it says the broker, that also means the implication is that means you as well. That doesn't necessarily just mean the broker. It just means RE/MAX distinctive intent, broadly. So the agent didn't insist that the silent partner participate in the agreement. So the assumption here is that, based on the way that this is worded, the assumption is that the owner, the party that was listing the property, the seller that was listing the property, advised the agent that there was a silent partner, but the agent didn't insist that the silent partner be part of the conversation. So this was the mistake. So if somebody ever tells you that there's a silent partner, you need to start engaging them with that and advise them, make sure that they are aware of it, of what's going on, because doing it behind the back will give us the result we're talking about here. So the result was the following execution of the sale agreement. The owner informed the silent partner that the property was being sold and asked him to attend the closing to sign the necessary documents. The partner refused to do so and let the real estate brokers know that the sale would not go forward. After the buyers were notified, they sued the sellers for specific performance under the contract. Then the silent partner sued the listing broker, alleging that the broker acted negligently by accepting forged signatures. So clearly there were other factors here. There's an allegation of some kind of forgery or something. Who knows what really was the result? The case was ultimately settled when the owner and the listing broker paid a settlement to the buyer to walk away from what was otherwise an invalid contract. Without this resolution, the buyer could have lost a significant amount of money paid to an architect for retrofitting the building's interior. Prevention. Many real estate errors and omissions claims could be avoided by simply exercising care to your clients. Obviously, getting the proper signatures or initials on all documents will help protect you and your clients while ensuring that the transaction will proceed in a straightforward and legally binding fashion. However, it is just as important to know who your clients are and properly communicate with every one of them. When speaking to each client, include information such as what the comparative market value is, what to expect during the listing period, what happens after the property goes under the contract. Good communication skills combined with other risk reduction methods will help avoid need to pay costly attorney's fees and settlements. So for those of you who are new, Pearl Insurance is the one who produces this flyer. They are our E&O provider, and they produce these scenarios based on real life claims that were placed with their company, with their insurance company, and they produce these things so that we can educate you all on these kinds of things. So, does anybody have any thoughts or notice anything, any other pieces to the situation that could apply and might have bearing on how we do business?
And I joined a couple minutes late, so I might have missed this. Does it indicate what type of partnership it was?
It didn't. It didn't say. It didn't. It
So,
did. Yeah.
in the event of a general partner and a limited partner that's still a partnership, the general partner can sign on behalf of the entity. Do we still need the release of the limited partner?
Well, that's a good question. And I think what it really does is, I guess it depends on what the documents say. If we're talking, it wasn't clear if the ownership was an LLC or if it was just two individuals that owned it as a business. So that part of it wasn't clear. Um, it sounds to me like it might not have been an LLC. It might have just been two individuals, but regardless, that's why it's very important to make sure that you have a title company attorney vet the LLC documents to make sure that this person who is claiming to be the seller has the full and complete and unrestricted authority to sell that property, regardless of who may or may not have equity ownership in an LLC or otherwise. So always make sure that you verify with your title companies at the time that you're listing the property. You know, to get an opinion to say, that yes, I believe that this is satisfactory for listing the property for sale and for signing the sale contract. Additionally, I would also say that you probably need to make sure, at the very least, you should probably, if there are silent parties, I would definitely counsel the seller to make sure that the seller that is signing informs all the other members to that of the sale and the terms of the sale. Because if it comes as a surprise, like this happened as a surprise, apparently it seems as though the silent partner wasn't informed until the very end, until right at the end at settlement, and so he wasn't informed until the very last minute, and then this is where it all blew up. So I think in this case, it sounds to me like the agent knew that there was a silent partner and did not insist on the silent partner being informed. That's what it sounds like to me. We have to kind of assume some things in the narrative here, but that's what it sounds like.
Yeah, I would argue also that because they mentioned about the forgery, that's also probably a big part of it, and not just.
Yeah, yeah, there was. Yeah, that's right. That's right. There was a forgery component to this too, and it's unclear how that. Yeah, that's unclear how that manifested. Yeah. Anybody else have any thoughts? Questions?
Nope,
A good little lesson though, right?
that due diligence.
Yeah,
Indeed, it is. Pay attention.
yeah, exactly. Ask a lot of questions, make sure everybody's informed, and if anybody starts talking like they want to hide something from somebody in the transaction, your
Run.
spidey senses should be getting alerted. All right, thanks everybody. Go hit the street. Go make some money.
Thank
Thank
you.
See y'all.
Every day, everyone.
Take care.
Bye.